Is that not? It is. It's just not plugged into the wall. That could be the problem.
Bring out the old press fast color.
Like at your 6 directly. Right?
She said sorry? She said
Yeah, I was doing that in college. After school, I was like walking into museums and student race. Just like, don't look too hard at this.
they never do.
What
Yeah. Yeah. Yeah, I did. I think they want me on the side a little bit, asking a bit about the same stuff I was just doing. Yeah, always good to
What
do that.
they're trying to say at rules about what they initially partisan, but
So initially I sent
but this is, I guess, maybe that's related. I was just specifically following what in addition.
No, it's not. You can notice I just plugged it in. Did you try switching it? Directions? Okay. Well, this. But if that's not, that's what's not working.
Oh, sure. You got it?
Yep, this one's working. So I have one. If you want to take that.
Oh, yeah.
See if you're able to get this in here. Yeah, thank you. Thanks for flagging. I was definitely going to miss out on my laptop sent me like a low batteries.
wasn't surprised. I was surprised by how much people were responding to the stuff that I was concerned. The algorithms on it. Set for like a 4-hour my friend Peggy is visiting. So I was like, they're going to come to play for lunch. I was like, I'll let you know. We'll see what happens. He's American, so he's family here. I might have, I know a person though. We went to college together, and his parents are Methodist pastors. And so he like sort of grew up all over the world. Like he was born in Lithuania and went to we went to like elementary school in Milan, and then high school but he moved back. Actually, he was supposed to move back to DC because he got a job in USA. And he got an offer like 2 weeks before the they moved to London because they wanted a more challenging congregation. They're like, we actually don't like one version of like inner city congregation. Like lower income areas. They're just like some of the most amazing like head of that right there. And my sister also works at USA. This is 2 years older and she works at USC. I was in the hospital. She was in the hospital when she found she was dying. And they were like, she was in the hospital on Wednesday. And they were like, we can help her bring stuff on Friday. And so she came out and she's like, oh my God, I hope it's on Friday. And she saw her earlier this week. And she was just like, it was like watching someone process it. Like that, you know, like she's just so burned out. It's horrible. The whole thing. Every single one of them was like devoted to like that sort of service idea. But this isn't a jam. It really sucks. Sometimes you want to stop this. I was talking to him yesterday. It was just like, he's always been sort of like me anyway. Young fellow national student. He's like a platform supporter, like in the 20th time. Like he really brought like some pure soul emotion and rhetoric. And he's just been pushed so far in his career. Like he is such a it's kind of crazy. But it sucks. I think that was just so U.S. formula is 70% of global formula. Our industry is like it's he's working for a non-profit based in or trying to cure grants or something like that. But he's like, I'm not coming back to the US. We're just my values are the line. So, yeah, he sucks. It's just, he's in like, most situations he's in. It's just one of those things.
The subcommittee will come to order. Without objection, the chair is authorized to declare a recess at any time. We welcome everyone here today for a joint hearing on judicial overreach in the federal courts. Before I recognize myself, I'd ask unanimous consent that members of the full committee, but not of the subcommittees, Mr. Moskowitz and Mr. Biggs, be allowed to sit in and participate in today's hearing. Without objection, so ordered. And as a point of personal privilege, before I make my opening statement. Speaker Gingrich, I've been here now, this is my 25th year on the Hill, and the first time I've had the pleasure of having you as a witness. I will cherish that as much as I cherish the time I once carried your bag off of an airplane in San Diego and found out you were the speaker, but you were also a regular guy. So with that, I'll now recognize myself for an opening statement. We are here today because a major malfunction in the federal judiciary has been recognized by both Republicans and Democrats. Activist district court judges usurping themselves with their Article III power and imposing on the nation injunctions beyond the scope of what the United States Congress under statute has given federal judges. These rogue judge rulings are a new resistance to the Trump administration and the only time in which judges in robes in this number have felt it necessary to participate in the political process rather than to participate in the Article III powers given to them both by the Constitution and by statute. President Trump was elected to assert many policies, including the deportation of criminal aliens. He did so publicly and was elected by a majority of Americans and the vast majority of the Electoral College. But he also did so in stark contrast to executive orders of the previous administration. Time and time again, rogue judges have asserted, as though they were 5 of the 9 members of the Supreme Court, their authority when the president was doing nothing more than undoing a policy of his predecessor, one which they seemed to have no problem with in the previous administration. Let me be clear, it should never have come to this. It is within the Supreme Court's ability to rule appropriately that judges have exceeded their jurisdiction. Time and time again, the High Court has ruled on the substance of the ruling rather than on the inappropriate nature of an injunction overly broad and affecting hundreds, thousands, or millions of people beyond the plaintiffs before that court. Just last night, a judge halted the administration's plan to end temporary protective status for about 350,000 Venezuelans that Joe Biden welcomed into this country and gave temporary protective status to. Temporary seems not to be a word understood by the court. If President Biden could give protective status temporarily, how, in fact, could it not be the prerogative of the next president to undo that status? Nowhere in that protective status was there an act of Congress or a recognition that temporary equals permanent. This is but the latest outrage coming from lower, or at least I might say the lowest courts. I have said from the start that my colleagues on the other side of the aisle should support this legislation. After all, it was the Biden administration who opposed these universal injunctions and said they were illegitimate. In fact, legislation in the last Congress, authored by a Democrat, is substantially similar to the one that we offer today and would have the same effect. To quote the previous administration's Solicitor General, literally the woman who spoke on behalf of the administration before the court, she said, "The government must prevail in every suit to keep its policy in force, but plaintiffs can derail a federal program nationwide with just one lower court victory," end quote. Those words by Elizabeth Prolongar, President Biden's own Solicitor General, were from October 2024. In other words, after almost the entire 4 years of the Biden administration, they still believed, and believed till the end, that this was wrong. And yet, we will probably hear today no support on the other side of the aisle. In fact, this is not new, but it is not old. For 180 years of our nation, there were no such injunctions. Only beginning in 1963, did district courts begin to, in relatively small amounts, believe that they could do these without multiple plaintiffs from multiple circuits. From 2001 to 2023, the number grew to 96, but an incredible 64 of those occurred during only 4 years, the 4 years of President Trump, meaning that more than half of all injunctions in this millennium, this century, were against President Trump in his first 4 years. That used to seem like a lot, but during President Trump's first 9 weeks in office this year, he has already faced more nationwide injunctions than President Joe Biden did in his entire 4 years. The federal judiciary isn't interpreting the law. It is impeding the presidency. It is, in fact, not co-equal, but holding itself to be superior. Since Marbury, Madison, there's no question at all that the third branch says it's the last word. And we have accepted that for over 200 years. But that acceptance is for the Supreme Court making a final decision, not one of over 700 district and appellate judges. The reality is every judge is considering himself not to be an associate justice, not to even be the chief justice, but in fact to be a combination of the justice and the President of the United States. This demands that we make a change and make it quickly. When a judge believes that he can order a full plane of criminal aliens back to U.S. soil, essentially saying that 200 years of a statute is to be overturned by his quick order without knowing even who was on the airplane. And finally, demanding that President Trump spend $2 billion in a single weekend, and I repeat, a weekend, and not tolerating any delay because that money was money that that judge believed should be spent, even if it was reckless and illegal. The last one might be understandable because a judge might have misunderstood and thought that President Biden was still in the White House, or that $2 billion, like the $188 billion that President Biden tried to forgive in student loans, and then, when thwarted by the United States Supreme Court, found a workaround that he believed was legitimate and gave away another $8 billion in loan forgiveness. No question at all, we had a rogue in the White House for 4 years. Many today will talk about the current occupant of the White House. But in fact, most of the rulings that are being overturned are simply undoing rogue activities of the previous administration. The No Rogues Ruling Act does not eliminate the ability of judges to make decisions. In fact, every decision made by a judge on behalf of a plaintiff would still go forward, but it would go forward only as to the plaintiff in front of him and not a nation as a whole determined by one judge, neither elected nor appointed to a position of sufficient power to speak on behalf of the entire nation. And with that, I would recognize the ranking member, Mr. Johnson, for his opening statement.
Thank you, Mr. Chairman, and thank you to the witnesses for your appearance today. Special shout out to former Speaker Newt Gingrich from the great state of Georgia. Professor Gingrich, good to see you. Of the many troubling actions the Trump administration has taken in its first 71 days, among the most damaging are his authoritarian, dictatorial, and unprecedented use of presidential power to instill fear, intimidate, exact revenge against, and punish those who dare to stand up to him and hold him accountable to the laws of our nation. A climate of fear and trepidation has descended upon the nation. The people of America are more afraid today for our democracy and for their personal safety than ever in our lifetimes. College students have disappeared off the streets paramilitary style by plainclothes, mask-wearing individuals and held incognito for days before they are discovered thousands of miles away in some private for-profit ICE detention facility. Why? For exercising their free speech First Amendment rights. Universities, bastions of free thought, have been punished for having the wrong ideology by having their federal funding revoked. And major law firms that dared to have brought cases against King Trump have been targeted with blatantly unconstitutional executive orders that, if allowed to stand, would shut those law firms down. Unfortunately, mega law firms Paul Weiss and Skadden Arps chose to settle with the king by pledging to represent pro bono only those persons and causes that the king approved of. Shame on them. Then there are other law firms that have stood up to King Trump, and they have challenged his executive orders against them in court, and they have won. Kudos to the lawyers at Perkins Coie, Covington and Burling, and Jenner and Block, among others, for standing up for themselves and for the rule of law and for our democracy. Although federal courts have consistently ruled against these numerous unconstitutional executive orders of President Trump, the mere existence of these retaliatory executive orders should be chilling to all of us. There has been no semblance of due process or fairness in any of these cases. Trump acts first, he deports first, he revokes funding first, he blacklists law firms first, and then questions anyone who challenges him later. Somehow, in spite of this, we are here today to talk about the, quote, overreach, end quote, of the federal courts, not the overreach of the executive branch official who is doing the overreaching. Our Republican colleagues want us to believe that simply because the courts are exercising their Article III power of equitable relief to temporarily halt some of Trump's most excessive executive actions, it is a sign of rot in our judicial system, that it is somehow our courts and judges, not the president, who have gone rogue and are overreaching. I disagree, but more importantly, so do the numbers. Since day one of his second term, Trump has attempted to rework our constitutional system of government through presidential fiat, issuing a record 107 executive orders in his first 71 days in office. As I mentioned, many of these executive orders are unlawful or unconstitutional, and the president does not have the power to change the Constitution through executive order, even if his name is Donald Trump. Naturally, they have been challenged in court, and of the over 150 cases filed against the Trump administration, judges have ruled against him 46 times. Of those 46, only 17 are nationwide injunctions. The cases are spread across district courts throughout the country, and judges appointed by Democrat and Republican presidents have all ruled against Donald Trump. What we are seeing playing out in courts across the country today is the judicial system working exactly as it should. America's federal courts have been handed case after case, challenging executive orders standing on questionable legal footing. And yet, the proportionally small number of nationwide injunctions shows the restraint exhibited by the judges considering those cases. I don't know what Donald Trump thought would happen when the cases made their way to the judicial branch, but clearly he has had enough with losing in court. Instead of letting the rule of law play out, Trump and his allies here in Congress now have chosen to go on the attack. Trump and his cronies have called federal judges rogue and corrupt. A judge it was suggested that a judge supports terrorists, and they've called judicial rulings judicial coups, MAGA Republicans in Congress have called for judges to be impeached, not because they committed a high crime or misdemeanor, but simply because they ruled against Trump. And far-right media personalities have attacked the judges' families, publicizing their personal information for millions of their riled-up followers on social media. What I had just described is nothing less than a full-scale assault on our entire judicial system, and it is putting judges, their family, and their staff lives at risk. We don't agree on much on this committee, but we should be able to agree that this is wrong, and we should be able to agree to back away from language demonizing the judicial branch, no matter what political party we belong to. Today's hearing is not just about helping Donald Trump undermine the judicial branch, though, well, let me say that this hearing is not just about helping Donald Trump undermine the judicial branch, though certainly it is about that. But Republicans on this committee are sending a message to anyone who dares to stand up to Donald Trump. If you step out of line, they will target you next. We cannot afford to allow what Donald Trump is doing through retaliatory executive orders, through targeting immigrants, through threatening lawyers, through vilifying judges, to become the normal. Our Constitution is being tested, and throughout American history, it has stood up to attempts to weaken its protections. Americans across the country are watching, and they know they didn't vote for Trump to destroy our democracy. They voted for Trump because he promised to lower the cost of living, and Trump has betrayed their trust. Prices are going up, and our economy is headed towards recession as co-President Musk threatens to take away people's Social Security, Medicaid, Medicare, SNAP benefits, and veterans care. Trump is doing nothing to deliver on the promises to the American people. I stand with my fellow Americans, with the federal judges who continue to bravely do their jobs in the face of criticism, and I yield back.
I now recognize the chairman of the Subcommittee on the Constitution and Limited Government, Mr. Roy, for his opening statement.
I want to thank the gentleman from California and my co-chairman on this hearing. It's an important hearing. I thank him for his work on this issue as well as his legislation addressing the matter. And I'd like to welcome the guests who are joining us here today. Appreciate your time, obviously, particularly you, Mr. Speaker, and your great service to this country, and great to have your expertise here. We thank you. And I also want to give a shout out to Cindy Romero. I met Ms. Romero last August in Aurora, Colorado, and I appreciate what she's going to be here to testify about today and her great service. So with that, I would like to take a slightly different angle as the chairman of the Subcommittee on the Constitution than the direction that my friend from California took, because I want to emphasize the judicial overreach we've witnessed over the last 2 months and nationwide injunctions more broadly that are undermining the constitutional structure our founders so wisely envisioned. The nature of the executive branch was a primary point of contention at the Constitutional Convention. Some delegates favored a plural executive, thinking that this arrangement would better preserve liberty. But they were wrong, and our founders wisely resisted their calls. Instead, the Constitution lodges the executive power in a single president of the United States. Alexander Hamilton offered the classic defense of this arrangement in Federalist 70, emphasizing that a vigorous and energetic executive is necessary to defend our liberty from foreign threats. Hamilton rightly argued that unity in the executive was the essential ingredient in this formula. Only a single executive could act with the decision, activity, secrecy, and dispatch necessary to adequately carry out the office. And on a note, I have introduced legislation in the past, it's called the Article 1 Act, to try to cabin in the executive branch when it's not necessarily working directly with Congress, and I'm happy to work with my colleagues on the other side of the aisle on these concepts when we have these lingering emergencies, in many cases these national emergencies that date back to the 1970s. There are times for the Congress and for the legislative branch to assert itself, but the president's authority is at its zenith when we're talking about his actions as commander-in-chief. Injunctions and temporary restraining orders halting presidential actions nationwide threaten the key feature of our constitutional architecture, undermining the core premise of unity in the executive branch, the unitary executive, as we refer to it. Even the most strident proponents of a plural executive at the Constitutional Convention advocated for an executive council of 3, maybe 5 members. Today, in practice, we are governed by an executive council of 678. The nationally elected president and 677 district court judges, each of whom retains a functional veto over executive actions through their power to issue nationwide injunctions. Scholars have long understood that a hostile judiciary or even a single hostile judge could abuse its power to issue nationwide injunctions to infringe upon the lawful authority of the President of the United States. Now, that's not a partisan point. I've got numerous examples of our colleagues on the other side of the aisle who have raised these concerns. The Biden administration's Solicitor General, Elizabeth Prelogar, told the Supreme Court as recently as 2024 that, quote, a court of equity may grant relief only to the parties before it. The district court violated that principle by issuing a nationwide injunction, ... In 2022, Solicitor General Prelogar asked the Supreme Court to address nationwide injunctions as permissible relief in the United States versus Texas, arguing that district courts normally, quote, should only provide relief for the benefit of the prevailing challenger. What happened there was our Democratic colleagues started realizing that when Republicans went to district courts to get injunctions against their president, that suddenly they didn't like it so much. So they were raising concerns. Justice Elena Kagan spoke out against nationwide injunctions by a single district judge in 22, quote, the ability of a single judge to stop implementation of a policy across the country. She stated, in the Trump years, people used to go to the Northern District of California, and in the Biden years, they go to Texas. Just can't be right that one district judge can stop a nationwide policy in its tracks and leave it stopped for the years that it takes to go through the normal process. Former United States Rep. Mondaire Jones introduced the Injunction Reform Act in 2022. I could go through the quotes that he offered, but I won't. I can offer those for the record without objection. In a letter to William Torrance dated June 11, 1815, Thomas Jefferson explained who decides constitutional questions. Certainly there is not a word in the Constitution which has given judges that power, authority to decide on the constitutionality of a law more than to the executive or legislative branches, meaning we all have an obligation and a role to do that. Questions of property, of character, and of crime being ascribed to the judges through a definite course of legal proceedings, laws involving such questions belong, of course, to them in the judiciary. And as they decide on them, ultimately and without appeal, they, of course, decide for themselves the constitutional validity of the law. In other words, our founders never intended the federal courts to have the ability to unilaterally decide constitutional questions, as these judges are unelected and were never given the power to legislate from the bench. Treating the courts as the final authority on public policy, grants them more power than even Madison's rejected Council of Revision proposal at the Constitutional Convention. Indeed, it happened regularly during the first Trump administration, as we pointed out. Now in the second Trump administration, it is on steroids. As of last week, district courts had issued no fewer than 17 nationwide injunctions against administrative actions, with scores more temporary restraining orders, or TROs as we call them, as barring the president from enacting the agenda upon which he was elected. Alexander Hamilton wrote in Federalist 78 that even the Supreme Court would wield neither force nor will over politics, indicating he never envisioned the judiciary having the final say on every political decision or action. Now these injunctions and TROs have even infringed upon what the Supreme Court has described as conclusive and preclusive presidential powers, including core presidential authorities to conduct foreign affairs and repel invasions. Now, I have got numerous examples of what we've been dealing with. Just so people know, this is a 56-page summary that I've got of the 158, it might be 159 now because we're having to track them on a daily basis, lawsuits against the administration and against the president for carrying out the agenda upon which he was elected. 17 injunctions, I think there are a great number more TROs, and the cases we're talking about, without going through all of them, nationwide TRO enjoining the Trump administration from freezing foreign assistance funding, enforcement order requiring the administration to pay approximately $2 billion within 36 hours. That's a judge singularly acting against the president's actions. Provisionally, another one, provisionally certifying a class and adjoining the Trump administration from deporting members of a foreign terrorist organization. A nationwide injunction adjoining the Trump administration from pausing, terminating, or amending any equity-related grants or contracts, DEI. a nationwide injunction enjoining the Trump administration from prohibiting federal funds from being spent to promote gender ideology, a nationwide TRO enjoining the Trump administration from prohibiting biological men from being housed in women's prisons, 2 injunctions regarding the administration for implementing an executive order considering transgender individuals in the military, birthright citizenship, issue after issue after issue that the administration is trying to act on according to the campaign upon which he ran. One in particular has earned the scrutiny it has received. Just 2 weeks ago, Judge Boasberg of the District Court of the District of Columbia ordered the administration to stop the deportation of members of Tren de Aragua, a violent Venezuelan gang that has terrorized cities and towns across the country. At this table, in this room, we heard testimony from Alexis Nungare, whose daughter Jocelyn was murdered by TDA in the suburbs of Houston. Right here, we heard her powerful testimony about what that gang has done to this country. We're going to hear from Ms. Romero today about what that gang did to her community in Aurora, Colorado. And here we have a single district judge who's asserting jurisdiction from the District of Columbia to tell the President of the United States that he cannot deport members of the violent TDA gang out of this country to keep our streets safe. That is not what is supposed to occur. Today's hearing, where we'll learn from constitutional scholars and real Americans about what is wrong with the current system, is a good start. We should carefully study whether Congress should push back against judicial overreach using its constitutional power to structure and fund the courts. Our Constitution did not create a plural executive or judicial tyranny. Today, we're far too close to both. With that, I yield back.
The gentleman yields back. We now recognize the subcommittee ranking member for her opening statements. Ms. Scanlon.
Thank you. Like the chairman of the subcommittee on the Constitution, as ranking member, I too would like to address the constitutional concerns raised by this hearing. Our Republican colleagues have called this hearing today for one reason, because this White House, this president, continues to lose over and over again in court. As people and groups from across the political spectrum challenge the barrage of unconstitutional and illegal executive actions taken by this White House in just the first few weeks of this term, because it doesn't matter if the judges were appointed by Bush or Biden or Obama or Reagan or by Trump himself. When the president attempts illegal or unconstitutional actions, United States judges, guided by the letter of the law, must rule against him. It's a confirmation of the total subservience of today's Republican Party to this president that their response to multiple judicial rulings of executive overreach is a hearing entitled Judicial Overreach and Constitutional Limits on Federal Courts, when we should be holding a hearing on presidential power grabs and constitutional limits on executive power. This is Civics 101. The Constitution provides in Article 1 that Congress writes the laws. In Article 2, the President administers the laws. And in Article 3, the courts interpret the laws. Our Republican colleagues are concerned about the unprecedented number of successful lawsuits challenging this president's executive overreach. But it's not the actions of the courts in interpreting our Constitution and laws that are unprecedented. It's the scope and breadth of this president's executive orders that are unprecedented. It's this president's attempt to go it alone, to usurp the power of Congress and we the people, to rewrite the laws of this country and the Constitution, and to reserve unto himself, rather than the judiciary, the right to interpret the laws and our Constitution. The sheer volume of unconstitutional and illegal actions taken by this president in just the first few weeks of his term has led some to wonder if the president fundamentally misunderstands the nature and terms of his Article 2 powers. Specifically, when Article 2, Section 3 says that the president shall take care to faithfully execute the laws passed by Congress, does this president think that the word execute means that he's supposed to kill laws rather than carry them out? Unfortunately, the underlying rationale for much of this action is a radical theory set forth in Project 2025 and elsewhere. It's one that would vest federal power in a unitary executive, sidelining two of the three co-equal branches of our government, Congress and the judiciary. We're here because Republicans who control the House and Senate have, thus far, chosen to abandon their constitutional duty to constrain an out-of-control executive branch. If they don't see anything wrong with it, their constituents do, And more of our colleagues would know that if they actually showed up at town halls in their districts. Our Constitution is built upon the rule of law, that no one is above the law, and our legal system is built on the idea of judicial independence. In the past 2 months, we've seen our judicial system working as the founders intended. And as the Supreme Court ruled in Madison versus Marbury over 200 years ago, it's the job of our judiciary to declare laws and executive actions unconstitutional if they're in conflict with the Constitution. The federal judges who've ruled against President Trump's unlawful power grabs are simply interpreting the Constitution and the laws passed by Congress to protect the rights of the American people. To suggest otherwise is to substitute a theory of executive primacy that is completely at odds with our constitutional history and separation of powers. Mr. Chairman, I wish that we could dismiss today's hearing as just political theory or theater, but the stakes are too high for the American people and their rights hang in the balance. While this administration has begun by attacking people it vilifies, including immigrants, students, or working people, no one should kid themselves. It's clear the rights of every American are at stake. When the White House and some of our colleagues claim the right to deny due process to immigrants who they claim have broken a law, that's a sham. Because if you don't support the rights of immigrants to due process, then you don't support anyone's right to due process. Because without due process, the government can do whatever it wants to anyone, including citizens, and they aren't able to defend themselves. What's to stop ICE from saying that Mr. Roy or Mr. Jordan is a member of a violent gang and shipping them out of the country? Attacks on our courts, whether in the form of executive orders punishing law firms and lawyers that dare to stand up for the rule of law, or hearings like this attempting to constrain the courts, or tweets urging impeachment or violence against judges, are part of a broader attack on the rule of law. Our Republican colleagues have shown that they're not concerned about civil rights and the rule of law. Their sole concern appears to be whether or not a federal judge has ruled against this administration. They've gone so far as to call for impeaching judges who rule against this White House, eliminating courts altogether, or advocating to cut off funding for the court system. The fact is, if the president wants to end his legal woes, he can simply follow the Constitution and our laws. Because if a president issues illegal executive orders, the courts are duty-bound to block them. But rather than accepting that reality, our Republican colleagues would rather hand the president the keys to unchecked authoritarian power. Let's be real. Americans elect a president every 4 years, not a king. Even if President Trump had won a landslide electoral victory, which he didn't, that would be beside the point. An electoral victory does not justify running roughshod over the courts and the Constitution, which every president is sworn to uphold. Presidential power is not absolute. When President Trump empowers Elon Musk to ignore laws Congress passed or slash funding Congress appropriated, he's undermining the power of the American people who voted us into office. If President Trump's agenda is as popular as he claims, he can work with his allies in Congress to convince the American people to support it. But he has no right to simply do whatever he wants just because House and Senate Republicans don't have the backbone to stop him. Democrats and independents are standing up against President Trump's blatant power grabs because if he can deny the rights of some people, there's nothing stopping him from denying the rights of all people all across America. And that should concern everyone in this room and everyone across this nation. I yield back.
Gentlelady yields back. We now recognize the chairman of the full committee for his opening statement, Mr. Jordan.
Thank you, Mr. Chairman. Who decides? That's the fundamental question. Who gets to make the call? Is it the guy whose name was on the ballot, or is it some bureaucrat? Is it the guy who got 77 million votes or some district judge? The left always says, trust the bureaucrat, trust the judge. It's the Faucis, it's the Boasbergs who get to make the call. After all, they're the experts. They're smarter than we the people. They're smarter than all us hillbillies in flyover country who voted for President Trump. Trust them. That's not how it works. We the people have the power. And you know what's interesting? For all the left's talk about democracy, they don't really trust it. Someone else on the ballot without a vote, without an election, So of course they like some judge issuing orders or injunctions that stop the head of the executive branch from doing what he said he was going to do when he ran for the job and when the American people elected him. Think about it. Here in D.C., an elected judge thinks she's better equipped to determine military readiness than the commander-in-chief. An unelected judge in California thinks he gets to decide how many probationary employees work in the executive branch, not the guy who was elected to run the executive branch. Another unelected federal district judge here in D.C. thinks he gets to decide how long illegal gang member terrorists stay in our country, not the president, not the commander-in-chief. And now that same judge gets randomly assigned the Hexeth case, and he'll get to determine who the Secretary of Defense can talk to and how he has to do it, not the president. I think Americans see through this all. They know Representative Iss's legislation is exactly what's needed. They know who they elected, and they want him to make decisions that affect the executive branch, that affect our country. So I want to thank our chairman, Mr. Issa and Mr. Roy, for this hearing. I want to thank Mr. Issa for his bill. Mr. Schmidt, a member of our committee, who we put his amendment on that bill, which I think makes it even stronger. We passed that legislation 4 weeks ago. It's going to be on the floor tomorrow. It's going to pass the House. I want to thank our witnesses for being here. Ms. Romero, what you've went through, thank you for coming. And of course, Speaker Gingrich, for your half a century of service to the Constitution and the country, thank you for joining us. That is the question, though. Who decides? The individuals that we, the people, elect, or someone else? I yield back.
Gentleman yields back. We now recognize the ranking member of the full committee, the gentleman from Maryland, Mr. Rossi.
Thank you very much, Mr. Chairman, and thanks to our witnesses for joining us today. So why have 34 federal judges from 11 different districts with a combined 474 years of service on the bench, judges appointed by Presidents Reagan, Bush, Clinton, Bush, Obama, and Trump, entered 57 different preliminary injunctions and temporary restraining orders against President Trump and Elon Musk's executive orders and actions, like the ones nullifying constitutional birthright citizenship, unilaterally dismantling congressionally created agencies, or impounding and diverting funds appropriated by Congress. Well, the majority says it's because these are radical judges. And they lead off, as our good Chairman Issa did, with Judge Jeb Boasberg, the chief judge of the District Court of the District of Columbia, who enjoined the mass roundup and deportation of immigrants to an infamous El Salvadoran prison in peacetime without any due process at all, allegedly under the Alien Enemies Act of 1798, a statute explicitly limited to wartime and military invasion. Some of our colleagues have been railing against Judge Boasberg for ordering the planes to be turned around. They say those planes were filled with terrorists, I think my good friend from Texas said. Well, here's one person of many who wasn't a terrorist on that flight or a gangbanger. His name's Kilmer Garcia. He's a Marylander married to a U.S. citizen who has a 5-year-old son with autism. And he went to pick up his son, but he was picked up first by ICE. And then he was shackled and put on that airplane and shipped off to the torturers of El Salvador without ever having the benefit of those two most beautiful words in the English language, due process. He never saw a judge. Nobody ever told him what he was being charged for. Nobody ever told him that there were any charges against him. And he was sent to a mega prison run by the self-proclaimed dictator of El Salvador. And yesterday, you know what happened, Mr. Chairman? The Trump administration admitted that it had made a mistake. He was not actually a gangbanger. He was not a criminal. It was all a mistake. If there'd been due process, maybe that would have been determined, but there wasn't. But they put him on that plane and he's El Salvador. Well, all's well that ends well, right? No. The administration says there's nothing they can do about it now because he's no longer in U.S. custody. This guy who lives in my state, married to a U.S. citizen with citizen children, he's stuck with the dictator of El Salvador. Well, Judge Boasberg, some of our colleagues want to impeach him. Look, some of our colleagues, they've got "for wanted" signs in the Cannon House office building with the names and faces of judges on them. They want to impeach them now. They want to impeach Judge Boasberg. Some of my colleagues should be alerted to this fact. Judge Boasberg was first named to the bench by President Bush. He was Justice Kavanaugh's roommate at Yale. Known in legal quarters as a very conservative judge, but they want to impeach him because he stood up for the rule of law.